a few days of getting that record and listening to it, I will issue it. I will try to do it as promptly as I can. Okay? Thank you very much, counsel, for coming today.
Thank you, Your Honor.
Good day. And like I said, next time you're in front of me, Miss Beck,
Yes, I will do that.
call my JA and get set on your own time, okay? And like I said, it'll just be a special setting just for it's you're not the only one. Okay, I'm not trying to single you out, and it's no problem for us.
I know I talk a lot. I'm sorry.
Have a great day.
Thank you.
Okay, finally, page 8, Alexander Bovtovich versus First Service Residential Nevada LLC, A-24-890821. Who's here for this?
Hello, my name is Alexander Bovtovich for the plaintiff.
Hello, my name is Irina Kemp. I am mom of Alexander Bovtovich.
Okay, are you able to hear them, Stephanie? Sure. Can you just say your name one more time for us, ma'am?
Irina Kemp.
She's the co-plaintiff. Okay, and Mr. McCain, go ahead.
Yes, Your Honor. This is Daniel McCain from Gordon Rees, bar number 13915 on behalf of First Service.
Okay, I read everything and I kept this on rather than issue a minute order because the plaintiffs are representing themselves, and so I wanted to make sure you guys understood what my ruling was going to be and had the opportunity to ask any questions if you were inclined to ask questions. So here's the thing. The motion to dismiss is warranted because of the way the complaint is drafted. Pain and suffering, loss of enjoyment of life, loss of wages, those are not individual causes of action. The emotional distress is the only cause of action here claimed, and you did not meet the elements required for emotional distress. So, like I said, I'm inclined to grant Mr. McCain's motion. But Mr. Bovtovich and Ms. Camp, do you have questions as to why I'm doing what I'm doing?
Well,
and what I would suggest too, because maybe your inclination is to refile this, we have a self-help center located on the first floor of the courthouse that you can go to, and they have sample documents and they have the elements worked out for different claims. And that might be a place for you all to start if you're going to continue to represent yourself here, because there are requirements when you file complaints that you have to meet, that if the other side decides to do a motion like this and it's warranted based on what's alleged, the motion's going to be successful if you don't meet the minimum requirements. Do you understand what I'm saying, Mr. Bovtovich and Ms. Camp?
Okay, could I present my argument though?
Yes, of course.
Okay, so I understand everything that you said, that's fine, but I think there's a bigger issue at hand. And you stated that you read everything, but if you read everything, you would have mentioned those issues. One of the main issues is the questionable behavior of the attorneys, as well as committed fraud on their behalf. The biggest issue is the document filed by the counsel, which says substitution of counsel, where they changed the counsel, but this document was signed by a Mr. Charles Wright, who has no connections to the defendant First Service Residential. This man, he is president of the Homeowners Association, the board. He has no authority to act on behalf of First Service Residential, which I emailed the counsel about that. I asked them, you know, I see the signature of this man who has no legal, he has no legal representations to answer in regards to this company. No one answered. I emailed First Service Residential asking the same question. Is this man allowed to make decisions in regards to your company? You're the defendant. No answer. And as far as I know, this man has absolutely no connections to this company. The second main issue was the phone call made by Mr. Schumacher, which he made before he was the counsel for this defendant. He made a phone call asking to talk to us before he was representing this client, which is a questionable act. But like I said, at this point, my biggest question is, whether actually First Service Residential hired this attorney or not. Because from what I see, this attorney is representing someone who is not First Service Residential and is committing fraud by representing this company.
Okay. Anything else before I allow Mr. McCain to respond?
Those are the two main issues: that phone call, the substitution of counsel, who's signed by the person who's not in charge of First Service, and is also missing a date on there.
Okay. Okay, Mr. McCain, any response?
Just very briefly, I would note with regards to the phone call, in his opposition, he attached a transcript of the phone call. Mr. Schumacher was indeed retained. Our office was retained. Prior to doing that, he reached out to per plaintiffs and asked for an extension of time to respond to the complaint. He left a voicemail, and that was it. He was retained at the time of the phone call, and to suggest there's anything illegal or unethical about it is ridiculous. As far as the substitution of counsel, that really is not plaintiff's purview. We drafted the substitution. We submitted it to our client, asked them to sign it and return it to us. They did. Whoever they had sign it is their business, and that's between us and our client, and that does not really pertain to the plaintiffs in this case. We are not in the habit of representing people that haven't hired us to retain them. And then I would just point out, Mr. Bovtovich just conceded to emailing and speaking with a party that's represented by counsel by emailing First Service, and that is inappropriate. As far as any order Your Honor is inclined to make, I would add, just for judicial notices purposes, that on the 5th of this month, plaintiffs were deemed vexatious litigants in Ms. Sturman's court. I don't know exactly how that would apply here as to refiling and stuff, but I just wanted to bring that to the court's attention. Other than that, I'm happy to answer any questions. If you wanted to get into the counter motion that they filed or anything like that, I'm happy to address those.
Okay. Mr. Bovtovich or Ms. Camp, do you want to respond at all before I make some comments?
Yes, I would like to respond about the phone call. It's in my exhibits and my counter motion when the phone call was made, when the counsel was actually hired to represent the defendant. It's all recorded with times. The phone call was made beforehand. It specifically, Mr. Schumacher asked that someone asked to hire him. He did not say someone already hired him for an extension of time. He said someone asked him to hire him. He wanted to talk to us. That is before he was the counsel. About who's signing the substitution of counsel, this is not something that I need to know. What I need to know, if this attorney is representing the defendant, otherwise we're wasting time. This person who signed that document is not employee or an agent of First Service Residential. This is public information. This is not something private I'm trying to find out. If this man has no relation to this company, why is he signing these documents? And why is this attorney going through without verifying this information? And I emailed them, in all honesty, asking this question to verify this information. If this man is able to make statements, sign documents in the court in regards to this defendant, which nobody ever answered. This is not a secret who the defendant is or who might represent them. If someone asked me if I had a counsel, is this your counsel? I would say yes. That's what I asked First Service Residential. I didn't ask them for any private information. I asked them, does this attorney represent your case? Nobody answered. So to me, well, what is the big deal of saying, yes, this is my attorney? No, this is not my attorney. What is all the secrets about in this case? And in regards to what he mentioned about Gloria Sturman, well, sure, they did. She did order us being vexatious, but if you look at that case, since you specifically stated it, she is a corrupt judge in this 8th Judicial District Court, which we have proved.
Right there. Sorry, we're going to stop right there. Here's why we're gonna stop, because I don't believe I do, and if I've missed it, I'm sorry, but like when somebody's declared vexatious, how they're declared vexatious, sometimes it carries over into other cases, sometimes it doesn't. I don't have something in front of me that's stating that carries over into this case, so I'm not considering in this case. So I don't want you to go into argument about what happened in the other case,
Okay.
because we're not revisiting that. That's not in front of me.
Okay.
So, and I don't want any disparaging of another judge in this courtroom either. That's not affecting my decision in this case. The vexatious litigant declaration is not affecting my decision in this case, because I don't have something in front of me that says that carries over into any case you might file in the future. Okay?
Okay.
At least not that I've seen. But even if I had that in front of me, it doesn't go into my consideration here, because I'm going to tell you, my consideration here is what I discussed earlier. The motion is warranted. So I'm going to grant the motion. I'm going to deny the counter motion for default judgment and the counter motion for disqualification of attorney and punitive damages, okay? I don't find those to be justified. I want to also talk for a minute about communication. Look, the argument that communication has to go through the attorneys, I have parties, I don't want to say all the time, but if parties choose to waive that and talk to one another, it happens in family court, it happens in some other cases, parties can make that choice. Do I think it's the best choice? Depends on the circumstances and what's happening in the case. And a lot of times attorneys will cease from representing their clients when they find that's occurring. But at the same time, it's the party's obligation to say, I'm represented, go and talk to my attorney. If the party engages in the communication, I guess probably we have to look at who's initiating the communication. If you were just calling Mr. Bovtovich to say, is this in fact your attorney? Then that's why you were calling. So, but I don't really want to get into hashing out all those details, because frankly, it doesn't really matter for the sake of this motion. Okay, so
Judge,
Mr. McCain, your
could I
motion to
ask?
dismiss is granted. Mr. Bovtovich and Ms. Camp, you haven't met the requirements to maintain your complaint. Like I said, please, I encourage you, if you do want to bring this complaint, that you go to the self-help center, that you research what I'm talking about, where your claims for relief.
Could I ask a question? I'm sorry.
Yes, you can, but just give me a second.
Okay.
Emotional distress has certain elements that you have to go through and say, you have to allege facts that satisfy those elements. Now, it's just an alleged stage here, okay? So you have to make that allegation, but your allegations in the complaint as it's drafted right now are not sufficient to meet those standards. So that's why I'm granting the motion to dismiss. I'm denying the counter motion because I don't find cause here for a default judgment. You have a participating party on the other side. And as far as the disqualification of attorney fees and punitive damages, I don't find that that's warranted either. So I'm going to request that Mr. McCain draft the order and submit it to the court. If before he does that, I want him to email to you, Mr. Bovtovich and Ms. Camp, to see if you're willing to sign off, not because you agree with my ruling, because I imagine you do not, but because you agree that his order is consistent with my ruling and does in fact reflect the ruling I'm making today, which is granting his motion to dismiss. If you do not want to sign off on his order, you can submit your own competing order, but you need to do that promptly. So, Mr. McCain, how quickly can you email them your proposed order?
Probably early next week, Your Honor. I'm heading out of town for a funeral on Thursday.
So get them the order no later than the 23rd. And from the date they receive it, they'll have until the 30th to review it and let you know if they can sign off on it or if they want to submit a competing order. If you do not hear from them by the 30th, or they tell you they want to submit a competing order, you need to submit your order by the 31st. And from thereafter, from the time I receive Mr. McCain's order, I will give 7 days for Mr. Bovtovich and Ms. Camp to submit their competing order if they haven't signed Mr. McCain's order. And I will sign an order on or after August 7th in this case, okay? Any questions? I'm going to start first with Mr. McCain, and then I'll come to you, Mr. Bovtovich, just because Mr. McCain's a lawyer, and this isn't his first rodeo. I'm anticipating, I don't know if you've appeared in front of me before. You don't look familiar, but you might have. Do you have any questions, Mr. McCain, about what I'm ruling or what I want you to do as far as drafting the order?
Not as far as what you've said so far. I don't believe we've addressed our motion to strike. If you want to get into that, how would you like me to address that in the order here?
Your motion to strike, are you talking about motion to strike and any other sanction the court deems appropriate? Okay,
Correct. They've alleged and asserted illegal and unethical conduct on behalf of my client and my firm without basis. It's all on public record. It's inappropriate. They filed their...
Your motion to strike is granted. Okay?
Thank you, Your Honor.
I'm not granting additional sanctions, however, at this time. So, but your motion to strike is granted. As far as the allegations that are made against you, your firm, that can be stricken from the record. Okay?
Thank you, Your Honor.
Okay. Okay. Mr. Bovtovich and Ms. Camp, questions?
Okay, it's not really a question. It's more of a statement. And, you know, I'm sorry I'm being very honest and direct with you and no disrespect, but you've listened to the argument this attorney presented. You did not even address the questions that I have asked you. You have not addressed the two issues that I have presented you with. You, at this point, you're ruling a decision on a motion which is not filed on behalf of the defendant that we're suing. You are ruling on a fraudulent motion to dismiss, even though I presented you with the facts that this person who signed this document is not First Service Residential. Instead of you trying to verify this, you completely brushed it off and told me no. And the phone call, you did not investigate it. I saw you having hearings earlier today. You investigate everything. How come when it comes to our turn, and yes, it's all public record, I put my evidence there, what they did, exactly, I'm not afraid to say what they did, but you have not addressed a single thing of what I said. First of all, before having this motion to dismiss, you should have investigated whether this person who signed this document is actually the defendant. Because I brought forth claims that it is not true. This is a fraudulent document signed by someone who has no say in First Service Residential. Instead of investigating it, you approved their motion to dismiss. That is all that I have to say. You did not address anything that I said. You addressed everything they said. So how have you made a just, and this is not a just hearing nor a just ruling.
Okay. Do you want to say anything else?
Yes,
No.
I will be filing an affidavit to disqualify a Judge Anna Albertson for participating in corruption later today.
Okay. I understand. I believe I understand what you're stating. And if you feel like you've had the opportunity to make the record you want to make today, or do you want to say anything additional?
I already said everything I have, and you said everything you have. You have not addressed any of my questions or evidence that I brought forth. You did not.
Okay, thank you, sir. Mr. McCain, anything additional from you?
No, Your Honor.
Okay, I will look out for the proposed order, and like I said, I will sign it on or before or on or after August 7th. I'm giving that much time because I think that to allow both parties to either submit competing orders or to sign off on the same order. If I do receive an order signed off by both of you, I will sign it upon receipt or upon review after I receive it, and we'll go from there. Thank you, counsel, for being here. Thank you, Mr. Bovtovich and Ms. Camp, for your participation today. Have a good day, everybody.
You too, Your Honor.